Hello all, we may have gotten an early Christmas present. And no, it's not me, even though I'm sure you're happy to see my face again. It's been a while since I recorded a video, but we're talking today about breaking news. These news didn't happen today, but they're relevant today nonetheless. And if you're a US registered LLC or a business owner, you may want to know. So what actually happened? On December 3rd, 2024, a Texas federal court preliminarily blocked the Corporate Transparency Act, also known as CTA, which basically required almost all US businesses, especially LLCs and smaller businesses, to report stakeholder information, also known as beneficial ownership information, also known as BOI report. And that report was to be filed to the Treasury Department through the FinCEN network, which is also known as the Financial Crimes Enforcement Network. Yes, even if you're not engaged in any financial crimes or crimes in general, you would still have to file this report according to the CTA. And just to remind you, in case you don't remember, CTA was enacted on January 1st, 2021 and went into effect in 2024. The act basically required almost all US businesses to file the beneficial ownership report, which made it approximately 32.6 million business entities that are existing, plus every single new one, pretty much. And from the federal government's viewpoint, the law's function, which is basically to combat any illicit economic activity as well as money laundering, falls directly into Congress's regulatory duties and authority. If you want to know more about what BOI reporting is and why it came into being, you can watch a video I made about a year ago. From the very onstart, it was very clear that there would be lawsuits against this. And lo and behold, there were a lot. And one of them I want to point out specifically because that's what we're talking about, is the lawsuit that was brought by a few plaintiffs, but mainly a family-run firearms retailer called Texas Top Cop Shop Inc., as well as some others, and the Libertarian Party of Mississippi. The lawsuit alleged that the CTA falls outside of Congress's power to regulate interstate and foreign commerce. Judge Mazand said, and I'm going to paraphrase him, but he said something along the lines that if a company is a company, it doesn't need the Congress with some superpower to regulate it, basically meaning that if you're just starting a company and filed formation documents to do business, that doesn't mean you're involved in interstate commerce, and therefore the Congress can't regulate the business in every single respect. And so the judge basically concluded that in this specific instance, the plaintiffs would suffer irreparable harm, which is, I guess, the necessary standard for a preliminary relief, saying that it would take too much effort and time and resources to file the BOI report. And to be fair, even FinCEN acknowledged that BOI reporting will cost additional resources just because administratively it takes time and money to do, even though filing the report itself is actually free and can be done online. Please keep in mind that the court's decision is not the final determination to say that CTA is unconstitutional. What it does say is that it's likely unconstitutional. Earlier this year, I think around March, there was another district court in Alabama that held CTA unconstitutional, and unfortunately it only applied to the plaintiffs. So FinCEN actually said that they would cease the reporting requirement specifically from that plaintiff, but will continue requiring it from everybody else. In our case, with the Texas court's ruling, it applies nationwide. As I've mentioned before, the CTA has faced a lot of pushback from courts and lawmakers from the very beginning. Some contend that FinCEN didn't publicize enough material about the requirements and processes on how to file the report, and others raised constitutional concerns, including that filing the report violates the First Amendment or constitutes an illegal search or seizure under the Fourth Amendment and exceeds Congress's powers. It is very important to remember that the preliminary injunction is not the final determination that CTA is unconstitutional. In fact, this Texas's court decision contradicts other federal court decisions that were held in Oregon, Michigan, and Virginia, in all of which cases these courts denied the plaintiffs' allegations that the CTA was unconstitutional. And I guess it's not a huge surprise to hear that the government is appealing. On December 5th, 2024. The government filed a notice to appeal in the U.S. Court of Appeals for the Fifth Circuit, challenging the preliminary injunction. So with all of this in mind, what does this mean for you, the business owner? Well, the CTA requirement is to file the BOI reporting for all entities before January 1st, 2025. With the preliminary injunction, this deadline doesn't exist anymore, so meaning you don't have to do this. However, we all know that there is an appeal process going on, and in case this court's ruling is overturned, the January 1st deadline will come back, and the penalties will come back as well. As of recording this video on December 8th, 2024, there isn't very much information about what FinCEN thinks about that. A lot of professionals are watching very carefully and expect that FinCEN at some point will issue a statement on its official website, maybe clarifying the position or giving a suggestion or advice to you, those who have not filed the BOI reporting yet. Right now, you can still file the BOI report online with FinCEN on their website. The link is included in the description of this video. And you can also file by paper if you'd like. It is still free of charge to file it yourself. Obviously, if you engage services of a professional, that will cost you money to do that. So the question on whether you should still file prior to January 1st, 2025 or not is a really difficult question to answer right now. There isn't much information available. We don't know the expectations. I'll just tell you that if the court rulings is overturned, the January 1st deadline will come back and the penalties will come back. And if you want to know more about what the penalties are for willingly and knowingly not complying with this reporting requirement, you may want to watch my video previously. It's linked in the description because there I specify what the penalties are, and they are harsh, to put it mildly. If I were you, I would be watching the news eagerly to see what FinCEN says about all of this, what FinCEN's expectations are. Talk to your tax professionals. You can register for a free tax consultation with me on my website, liliacpa.com. And I would say that if you decide not to file and then the court ruling is overturned, let's say sometime next year, I would really hope to see that there would be some kind of a break or forgiveness or forgiving time period for businesses that haven't filed the BOI reporting due to this preliminary injunction. But it may be wishful thinking. So what do you think about all of this? Are you excited? Are you pleased? Are you stressed? Have you already filed the report? Are you filing it? Do you not want to file it? You don't need to answer those questions to me, but I would highly recommend to raise all of these with your tax accountant or whoever works with your business before the end of the year. With all of this, I wish you a very Merry Christmas and hope to see you in the next video.